Please be ready for a dictation of the judgment of the Supreme Court of India, rendered on 27th November 2020. 5 seconds. Start. In the Supreme Court of India, Criminal Appellate Jurisdiction, Criminal Appeal number 742 of 2020, arising out of SLP number 5598 of 2020. Human liberty and the role of courts. Human liberty is a precious constitutional value which is undoubtedly subject to regulation by validly enacted legislation. As such, the citizen is subject to the edicts of criminal law and procedure. Section 482 recognizes the inherent power of the High Court to make such orders as are necessary to give effect to the provisions of the CRPC or prevent abuse of the process of any court or otherwise to secure the ends of justice. Decisions of this court require the High Courts in exercising the jurisdiction entrusted to them under Section 482 to act with circumspection in emphasizing that the High Court must exercise this power with a sense of restraint. The decisions of this court are founded on the basic principle that the due enforcement of criminal law should not be obstructed by the accused taking recourse to artifices and strategies. The public interest in ensuring the due investigation of crime is protected by ensuring that the inherent power of the High Court is exercised with caution. That indeed is one and a significant end of the spectrum. The other end of the spectrum is equally important: the recognition by Section 482 of the power inhering in the High Court to prevent the abuse of process or to secure the ends of justice is a valuable safeguard for protecting liberty. The Code of Criminal Procedure of 1898 was enacted by a legislature which was not subject to constitutional rights and limitations, yet it recognized the inherent power in Section 561A. Post-independence, the recognition by Parliament of the inherent power of the High Court must be construed as an aid to preserve the constitutional value of liberty. The writ of liberty runs through the fabric of the Constitution. The need to ensure the fair investigation of crime is undoubtedly important in itself because it protects at one level the rights of the victim and at a more fundamental level the societal interest in ensuring that crime is investigated and dealt with in accordance with law. On the other hand, the misuse of the criminal law is a matter of which the High Court and the lower courts in this country must be alive. In the present case, the High Court could not but have been cognizant of the specific ground which was raised before it by the appellant, that he was being made a target as a part of a series of occurrences which have been taking place since April 2020. The specific case of the appellant is that he has been targeted because his opinions on his television channel are unpalatable to authority. Whether the appellant has established a case for quashing the FIR is something on which the High Court will take a final view when the proceedings are listed before it, when we are clearly of the view that in failing to make even a prima facie evaluation of the FIR, the High Court abdicated its constitutional duty and function as a protector of liberty. Courts must be alive to the need to safeguard the public interest in ensuring that the due enforcement of criminal law is not obstructed. The fair investigation of crime is an aid to it. Equally, it is the duty of courts across the spectrum, the district judiciary, the high courts, and the Supreme Court, to ensure that the criminal law does not become a weapon for the selective harassment of citizens. Stop.